to speak on a topic that I think in 18 years of our conferences we have actually never covered. They reached out to me over the last couple of years saying this topic is very critical to yourselves and to your clients, and I should look into it. They sent me a video of our presenter presenting this topic, which was actually, I think, more of like a 3-hour presentation, a lot of information, but it really opened up my eyes. I thought the information was critical and something that would be unique to bring to you, that you can bring to your clients. Harry Barth has more than 40 years of experience in the financial services industry and counseling franchisees, business owners, and corporations nationwide. He has distinguished himself by being an asset protection advocate. Mr. Barth is the senior and managing partner of the law firm BarthCalderon. Mr. Barth was the 7th CFP. Yes, number 7. He has a master's of financial science and a master's in financial services and a doctorate in law. And did I mention he's also published a book as well. So with that, I'd like to bring up Mr. Harry Barth.
Exciting morning to be here with all of you. Really excited because earlier this morning I was doing a talk in Van Nuys, and I got here about 12 minutes ago. So I was saying, oh crap, you gotta drive. So if we would have gotten a ticket, we wouldn't have made it. So I'm really glad to be here. Now, one of the things that are really important, we talk about asset protection. Oh my God, that's a dry subject, you know, or how important is that? But let me explain something to you. In the world that you work in, because I also understand your world very well, we need to find and maintain differentiators. Everybody, you know, has their investment plan and their game plan. And in this morning's financial planning news, if you go to financialplanningnews.com, they talked about the investment advisor, investment manager of the future, and they said they're going to have to incorporate charitable giving, succession planning, estate planning, asset protection planning, and other services to differentiate themselves from the rest of the pack. So what I'm here to do today is to talk to you a little about one of the major differentiators in the world that we live in today, and that's protecting your client's assets from the claims of third-party creditors. Now people say, well, what's that? You know, so what I'm going to do is take a little time over the next hour with you and tell you what that is. And you'll see how that's a hot button. For those people in our industry that have adopted making sure not only we help our clients build those assets, but help those clients protect them, they will stay with you, they will bring more people to you, they will say, I know your guy or gal does this, but my company, my gal, they're bigger. They help me not only accumulate our assets, but protect them. And it amazes me when I think back over the last decades of all the things that we don't know. So little things today like, can they take away my 529 plan? Will I lose my house? What about my IRAs? Is it protected here in California? What if I live in Nevada? All those questions. So we're going to learn about that today, and I promise you, every one of you, they'll be a lot smarter than the time that I started. But let's start with 3 simple axioms. Axiom number 1, and it's absolutely critical, that no asset protection plan should be undertaken after the fact. Now, you may laugh and chuckle and say, oh, we wouldn't do that. We wouldn't call the fire insurance gal and say, hey, fire insurance gal, our home is burning. We'd like to increase the fire insurance. You laugh, I understand. Well, the auto insurance dude, oh my God, we had a horrible accident, people were injured, we're worried about the future, we don't have enough liability insurance. But believe it or not, we will get calls. Remember that stuff you spoke to us about on Wednesday afternoon at the Krakow? Well, we have a problem, can you help us out? Yeah, we can help create speed bumps, perhaps get better settlements for you, but it's only effective when there is no storm clouds on the horizon. When you, like life insurance, when you need it, you can't get it. Now, understand something about people, you know, and you know, you really need to think about this. People will come to us after they've had a problem. Here's what they'll say. What if I divorce my spouse? Will that help? No, they'll say it. People are desperate Okay? Husband just had a horrible, wife just had a horrible car wreck. Well, that's their problem. What if I divorce them? Maybe we can save some assets. What if we take all of our assets and dump it into a trust for our children? Can we do that? What if we give it to Uncle Louie and he holds it for us during this period of time? Desperation, desperation, desperation has no place in asset protection and professional and proper asset protection planning. So that's number one. Let's just kind of set that axiom aside, not after the fact. Now let's go to axiom number two. Axiom number two is interesting. Now don't ask me where this comes from. You tell me. People say to me, oh, my house is safe, Harry, right? I said, why? Because I have it in my living revocable trust. We hear this constantly. Now all of you may know that a living revocable trust, you know, the ones we use for estate planning, critical. It's critical that we have estate planning documents, but therefore, avoidance of probate, privacy, you know, some certain tax implications associated with it, incapacity, death, but not asset protection. People seem to feel, and we hear this question, you may think not, but your clients may think other. Okay, we have your investment account and it's titled in your living revocable trust. You know what they'll say? They'll say, well, if it's not protected, what did I even put it in there for? They seem to forget. So I think that that's a very important truism that we need to understand as well. These are the things I see, these are the things you need to know. Number three. Number three is really interesting. I have insurance for that. Now this is a good one. Now, they have umbrella liability insurance, umbrellas on top of umbrellas, and all of a sudden they begin to feel confident that their asset protection is well structured and in place. So we have a little conversation. The conversation kind of goes like this. Well, first of all, may I make it very clear that insurance is a cornerstone of asset protection planning, and it's a place to drive a plaintiff to in order to settle a claim. We have our part of money. But it's not an all and all, and let's explain why. People have this conception as well. Well, I have $1 million worth of umbrella insurance. That's enough. I have $5 million of umbrella, $10 million worth of umbrella. People seem to believe, and maybe you do too, that the amount of insurance that you have is the maximum amount of the judgment that will go against you. They just believe that. Oh, I have $3 million, I'm covered. Where did that come from? I have a client that has $10 million, I have a $22 million judgment. There is no relationship between the two, but your clients and even yourselves may think they do. Now, of course, it's true. We hear the old adage, if we have too much, it brings lawsuits. We hear the other adage, if we don't have enough, oh, I could lose my house. But we really need to know and understand this better. So now, when we talk about understanding insurance better, let's also bring in a little bit of what I consider to be a bit of a misrepresentation by the insurance industry. What kind of... Have you ever seen that commercial with the travelers guy with the red umbrella and he's bopping down the street, you know, and we have this umbrella and all the crap that falls out of the sky hits the umbrella and lands on the ground and doesn't land on you. People seem to believe, for some reason or other, that they have umbrella insurance, everything or every cause of action is covered. Well, may I strongly suggest that's not the case. There are many of my colleagues who spend their entire career suing insurance companies for bad faith claims to get them to pay. Now, if it was all that simple, the insurance policy would be one page long, right? This happens, we pay. This happens, we pay. But it's not one page long, is it? It's 65 pages of covenants, conditions, and exclusions. And they are not insignificant. So when someone turns around and says, well, I could buy $1 million worth of umbrella liability insurance for $250. That's great. Now think about it. Insurance companies are run by who? Actuaries. They have actuaries. That's $250 because they're not going to pay out a whole lot of money. That's what it shows. It's not a loss leader by the insurance company. Oh, we'll give you this for $250 so we can get your other insurance. It doesn't. It just doesn't work that way. So we have a bit of a problem associated with that. The other thing, too, is what's happened to us over the last 10, 15 years and accelerated over the last 8 years, especially here in California. I don't want to pick on California, but you see, more than likely, the big claims that come against us are things which are considered exemplary, special, and punitive. These are the things that happen if we are grossly negligent, or perhaps have an intentional misrepresentation. And they used to be, when I went to law school in the year of the flood, you had to have wanton, willful, and reckless conduct. You had to be a really bad dude to get whacked with punitive damages. But that's changed. What's changed, and I'm sure you've seen this perception, especially over the last 8 years, and I don't mean to wax political, but just a tad. Now it seems to have become, that if you're successful and manage to get some assets, you've worked real hard, right? You had a bunch of student loans, took a lot of risks, sometimes you didn't see your kids grow up. Sometimes you lost relationships because you worked so hard. But you've been successful. Why? The government helped you do it, didn't they? All right? The government helped you do it. You did it on the backs of the middle class, right? And you shouldn't be rewarded for what you do. You should be punished for what you do. So we'll tax you a little more. We'll raise the estate tax rate. Now, talking about the estate tax rate, how many of you are from California? Oh, I got to give you a California special. And for those of you not in California, you'll be falling on the ground and saying, thank God. So, this was just phenomenal. This was just Florida. You know, California has every single tax under the sun, right? Every single tax, except one, right? We don't have the death tax in California. Well, they have it in Washington, they have it in Oregon, but they don't have it in California. So, State Senator Scott Wiener introduces Senate Bill, California, I think it's 786. And 786 says, look, should the federal government, under President Trump, repeal the federal estate tax, we are now to vote a bill that will replace it with a California estate tax equal to the federal estate tax. You laugh. That bill is moving through the state legislature now. Now, you laugh. In 1982, California attempted to do that. It failed. But the composition of our population has changed since 1982, hasn't it? Just a little bit. And now, in 2012 and 2016, we passed the millionaire's income tax. So if you do well, here's your reward. More tax. All right? You know, the administration that didn't make it in this time was going to raise the estate tax from 40% to 45%. But what's the implication? The implication is that if you have assets, you are no longer a good guy or a good girl. We need to take that away from you and bring that to others. And our court system in the state of California and our court systems throughout the United States of America are more than willing to do that. Now, the reason I bring that up, especially now, in other words, you have no assets, who's worried about it? But when your clients have assets and you've done a great job and you've built their assets, then you're also building something else. The more successful you are, the more of a target your client has become. So now, wouldn't it be better to say, well, now that we've built some assets, we want to make sure we have walls around them to keep them protected. Now let me turn around and give you a story. Now this is a story maybe a little bit on the racy side, so to speak. And so, you know, when I went to law school, wanton, willful, and reckless conduct, because if any of you don't know this, the amount that your insurance companies pay for special, exemplary, and punitive damages, zero. So, how are we going to pay for that? And juries have become a little bit more than juries. They've become mini legislatures. How can we change your behavior? And if you remember Erin Andrews, she's the sportscaster, and there had some pervert, right, who was taking pictures through a keyhole at the hotel. $85 million because you took pictures of Erin Andrews. Now, no one's condoning that behavior, but what was the jury doing? The jury was legislating from the jury box. When Hulk Hogan has an affair with his next-door neighbor, $125 million. I said to one of the persons in my speech this morning, for $125 million, do you have an affair with your next? Absolutely. No question asked. 2 seconds, just tell me where to go now. Okay. Talking about changing behavior? That's a change in behavior. No. But what's happened, tailhook scandal. All right, another one, McDonald's coffee case. McDonald's coffee case, pour the hot coffee in her lap. Now, so what were they doing? They were controlling, in the tailhook case, You know, when you go to a hotel now, have you ever noticed what happened when you go to a hotel? They used to tell you, you know, Mr. Smith, you're in room 720. Now what do? Say it. Do you think there's a federal law that says thou shalt not say your room number? No. Think there's a California law, or another law, that says thou shalt not state the room number? No. What is it? It was 12 people in the jury box that whacked Hilton during the tailhook convention for saying what the numbers were so the servicemen knew where the gals had their rooms. And that changed the way we believe. So if we are caught up in that type of thing, we better take a look at some asset protection. So now talking about asset protection, I work with a lot of CPAs all the time, and they kind of say, well, you know, do you really need all that stuff? You know, just buy an insurance policy. We already know that may not be the best thing in the world. And then can the insurance company say, hey, January 1st, you're canceled. You're done. Now what? You know, I'm persona non grata. They won't give me interest. There's a non-coverable risk. It used to be covered. Now it's not. So now we turn around and we kind of look like this. So we turn around and say, you know, we now need to turn around and protect ourselves because the times, they've changed. So let's give you some interesting statistics that are really, really interesting. How many lawsuits do you think were filed in the United States last year? Take a guess. You can't be wrong. How many? You're wrong. Okay. So, whenever anybody else take a try? Lanny, right? How many? 22 million. Close but no cigar. I could do this all day long. Would you believe 50 million lawsuits were filed in the United States last year? What the hell is that all about? Think about it. Every time there's a divorce, lawsuit. Tax action, lawsuit. Immigration action, lawsuit. Environmental action, lawsuit. Tort action, lawsuit. Employment action, lawsuit. Every interaction with the judicial system, lawsuit. 50 million lawsuits. Oh my God. 95% of all litigation in the world occurs where? The United States. Only 5% outside the United States. And lawsuits and their attendant costs represent 4.7% of our gross domestic product. Now, that's a pretty scary statistic, but it gets more scary than that. I believe in two things that I've lived with over the last 30-some-odd years. One, that the United States has the most sophisticated legal system in the world. And we do. Nobody gets away without discovering every little thing at the end of the process. And there are a lot of highly skilled practitioners that are able to do it. But I also say, we're definitely a broken system as well. So when you have a broken system that's coordinated with the most sophisticated system, you wind up with a problem. So let me give you an example of that, a ludicrous one. We're going to go to a very specific one in a little while. So, there was a gal. You've looked this all up. She's a psychic, all right? And she's at Temple University Hospital, Philadelphia, Pennsylvania, and she needs a CAT scan. So they roll her into the CAT scan machine, and they roll her out of the CAT scan machine, and guess what? You got it. Lanny got it. He's smart, because he is psychic. Anyway, you got it. She had no psychic powers anymore. They were gone. This is America. What do we have to do? We need to sue. Yeah, now we're all getting it. We need to sue. So we got to sue the hospital, the doctors. We got to sue the manufacturers of the equipment because the gal lost her psychic powers. And sure enough, the jury gives her $975,000 for the loss of her psychic powers, and we all said, why? She should have known it before she went into it. Sure. This is nuts. This is nuts. This is absolutely nuts. Now, hang on. So, before I get to some specifics, because you're all going to get educated, as they say, before I get to the specifics, we need to turn around and take a look at a few things. So, asset protection is not new. It's been around a long time. So Darryl, let's just take a look at your audience here has been a marauding army. And for the last 20 years, you guys and gals have been fighting a war. Good war. And we lost some lives. And we lost some limbs. And this is back in medieval times now. We're going back to medieval times. And we spent a lot of money on this war, and we labored hard, but we won. We won. So what are we supposed to get if we win the war? The spoils of war. Years ago, I used to say the booty. But now the Kardashians came and that was done. I can't do it anymore. People yell at me, what are you talking about? You know, the pirates, yo, no more. Okay. So anyway, we spent the last 20 years doing hard labor. And we now bring all of the spoils of war back to our little idyllic village. And that little idyllic village, you've all seen it. You've seen The Lord of the Rings, it's Hobbitland. Right? And it's little thatched cottages and round doors. Right? Green, all the grass is green, the sky is blue, the clouds are like puffed marshmallows. And for you, let me change it to naive land. So you now bring it back to naive land. And you take everything you've worked so hard for the last 20 years, and lay it right down in the center of the plaza. What happens? The barbarians come out of the woods and take all your crap, as if you never worked a day in your life, and take it all away. So back then they realized that, right? They had barbarians, so what did they do? You've been to Europe, some of you. They built a castle, right? And it's because the castle with big, thick walls was designed to do what? Keep those barbarians out. And they kept all their treasures. The treasures were all the stuff in the spoils of war and protected people behind those walls of the castle. And then, that wasn't enough, was it? They dug a moat, right? They dug a moat. Go see it. I'm not making it up. There's a moat. You see the big moat. And then what did they fill the moat with? Water. We have water. Our water's cool. Make it more difficult. And what was allegedly inside the water? Alligators, crocodiles, pit vipers. How they got them to Muriel, England, I have no idea. And then they had turrets, right? And they had archers, and Mel Gibson throwing boiling oil over the side of the walls. So that's what they had. And what was the hope? The hope was when the barbarians came and they looked at all of the fortress that was built and all the things that were impassable, they would pass by their treasures and go someplace else. True? That's what they hoped. Now, I may be a practicing lawyer, but I also own and run a relatively large law firm. So it's a business. And this is important for you to understand. It's a business. And we have limited resources, limited numbers of attorneys, limited dollars that we can use to prosecute cases. We don't do this part, but prosecute law firms think this way. And now we have two people. We have Micah and Lanny, the two of them. And the two of you each have the spoils of war. And Lenny, he listened to me. He built a really good fortress. Your fortress, not so hot, okay? Well, you didn't need it, you got the insurance policy, whatever it means, whatever it is, God love you, okay? Now what happens is that Micah and Lanny decide to go out together and drag race your cars. And you're dragging down Chapman Boulevard here in California, and you run right into the Archdiocese school bus full of local nuns, okay? The nuns are unhappy, to say the least. And this is America. Even if they're nuns, it's nothing to do with anything else. They're going to sue you. The two of you get sued for the damages that you've caused. We are lucky enough to get the nuns' case. We do a little discovery and a little homework, and we decide and look that Lanny has taken the time and the effort before this happened to build reasonably good structures. Micah has not. Here's what's going to happen, ladies and gentlemen. This is a dirty, dark secret, but it's the truth. We're going to go to Lanny, and we're going to settle with you for the insurance amount that you have, because we're not going to spend the next 5 years trying to get behind those walls. And maybe we'll hit you up and get an extra 10 or 15% for the nuns. Micah, let's put all my lawyers to you, because we can get the highest and best use for our client by bringing all of our action against Micah, because we can reach his assets easier than we can reach yours. Ladies and gentlemen, that's the reality of the legal business. It has nothing to do sometimes with justice, it's something to do with fairness. It's all about the good old American buck. All right? And that's how it works. So Micah now gets the lawsuit and the wrath of the law firm. Now, is it just economics? Or there's some other things associated with lawsuits, aren't there? Like emotional distress, don't sleep at night, you know, all kinds of dirty, dark secrets could become public. Would have been better to avoid lawsuits. So now what we're going to do, all right, we got the background set a little bit. It's an abbreviated background set, as Jonathan said. It usually takes me an hour and a half or so to set the background before I get into the meat. But today we have the abbreviated, we call it rocket version. And in doing that, let's talk a little bit about the assets that we all have in our, excuse me. So, I'm going to take you through assets, all right? Now, in the materials that we have in here, you'll notice there's a little thing in here that says, just text us. There's a text set up. And if you do, here's my book. You'll get my book. There's about 10 or 12 different items that you can get, and material on the things that we're going to talk about today. So rather than distribute it out, you guys can get it all electronically. It's great stuff. I think you'll enjoy it. Let's talk about simple things. So let's take that we have Paul and Vicky. So Paul and Vicky are California residents. Now remember, not all of you from California, so I'm going to try to build in some things for the other states as well. But we're going to turn around and talk about what happens with Paul and Vicky. So first let's build a net worth for Paul and Vicky, fair enough? So Paul and Vicky, they have a house. The house is worth $1 million. All right? Not a big house in California. When I go to speak in Texas, and I say, how about, who's got the biggest house? And the big executive gets up, I do. They say, well, how much did it have? $450,000. I say, whoa, but it's true. But I tell them, you know, $450,000, you know, over there you get a mansion. Over here you can't get a redo on the flip and flop from HGTV. So anyway, you ever see those two? You know, they're all over the news now. Whatever their names are. So anyway, so they have a house that's $1 million. They have a $400,000 mortgage on it. Fair enough? $600,000 worth of equity. They took that house, and on the advice of counsel when they did their estate plan, they put that house where? Inside their living irrevocable trust. Fair enough? And they had a house that they didn't sell, because, you know, it's crappy timing, so they had their rental property. So we'll call it rental property number one. Is their old house that's worth $400,000, has a $100,000 mortgage on it, and they put that inside their trust. That's rental property. Now they're real estate barons. All right? Then they've been working hard with you guys, all right? And NFS and the Crown and other places, they have stocks, bonds, and cash in their bank accounts. Oh, maybe they have another $600,000-$700,000. They've done well. Then they have some retirement plans, you know. We still provide counsel for that, I think, maybe. Who knows, Department of Labor, whatever. So we have retirement plans. They have a 401k plan. They have $400,000 or $500,000 in that. And then they have Jewish accounts. I call them IRA and Roth. Okay? No. You laugh. You think for 1 second that the next financial plan that comes out of this guy Mnuchin, you know, in the Treasury Department is going to be Balducci's Save for Tomorrow? No. It's going to be Herman and Irving's Saving for Tomorrow plan. Always. Okay? Balducci will be Fast and Furious. Herman and Irving will deal with the bucks. Anyway, so what will happen is we have IRA, and IRA rolled over, so we have an IRA rollover account, maybe it has $400,000 in it, and then a traditional IRA has $150,000. So we got that all set up. Then what happened is, they decided that Paul and Vic, they have 4 kids. So they meet with you guys and you say, well, you know what you need to save for college? 529 plan. Sounds good. By the way, when Obama was president, on his Green Book budget, they wanted to eliminate 529 plans as a perk for the rich. That should be eliminated, all right? And, no joke, look it up. So, didn't pass. Neither did Hillary, but anyway, so, I'm not going to be political, but anyway, so what happened is that we have 529 plans, and you're Alex, right? And 6 months ago, you put $45,000, you know, for the kids into the 529 plan, and it's California college bound, okay? We're going to college, grandkids, kids going to college, we set that all up. Then what happened is, we all bought some life insurance, right? So life insurance guy, gal comes along and tells us why. You know, life insurance is more than one benefit. That's just death benefit, more than death benefit. We can create what? A supplemental pension plan, right? We put the money in, all right? We earn a bunch of money along the way. We don't have to pay any tax, and we can take it out, right? A series of loans along the way. Tax-free supplemental retirement plan. We love it. We bought some of that. We overfunded the life insurance policy, and we took that life insurance policy and made the beneficiary of that. So we have, let's say, $70,000 of cash values that are inside the life insurance policy. Then Paul and Vicky inherits a little cabin on the shores of Lake Tahoe, right? A little cabin on the shores of Lake Tahoe from her parents, and it's worth about $900,000. So Vicky's now inherited that when the parents passed away, unfortunately. Then some guy or gal came up and told you that everything's going to go to crap, right? We're going to have hyperinflation, government's going to print money, so what are we going to buy? Gold. So we buy gold. So Paul and Vicky bought $60,000 worth of gold. They put it in a box, shoved it underneath the bed. Sounds good. Now, what happened is that we have just a few assets left. So Paul and Vicky, we have three companies. One company, we'll call it, Big Hitchcock's, it's a hamburger business, and it's a California S corporation. Next company for another restaurant, the Delaware C Corporation, and the third company is a Nevada multi-member limited liability company, and it makes it complete. They're all worth $1 million a piece, and they all take $75,000 a year income out of it. Okay, sounds good. Sounds good. You like that, Paul? Well, that's good. Sounds good. We have no debt. Everyone's great. You guys have done great advice. It's wonderful. So now, one morning, all right, on the way to driving our children to school. By the way, it's a real case, but not with Vicky. And I'm going to abbreviate it to make it fast because I have limited time. Vicky is driving down a boulevard in Northern California at 7 o'clock in the morning in December. And what's going on at 7 o'clock in the morning traveling eastbound? Anybody know? Sun, directly in her eyes. Speed limit is 40 miles an hour. Vicky is on the cell phone, not paying much attention. Right? Vicky is driving along, kids are in the back seat, on the cell phone, can't see very well because of the sun. Speed limit is 40 miles an hour, she's doing 40 miles an hour. And what she doesn't see, and now we're not so funny anymore, there's a little girl. Little girl, 7 years old, pink bag, we've all seen this girl. Pink helmet, everything to live for, and everything wonderful. About to enter legally into a crosswalk at 7 o'clock in the morning. What she's doing there alone, where the parents were, don't know. School crossing was 3-4 blocks down the road with a crossing guard. She's crossing here. She presses the button, the little white guy lights up, she enters the intersection. Vicky hits that little girl at 40 miles an hour. It could have been we changed the lanes on the freeway and didn't see the motorcyclist. It could have been like 2 cases we just got in our office last week, a 16-year-old, a 17-year-old child, drinking too much of yours, driving your car, and killed somebody. It could have been someone fell off the roof at your house. It could have been a personal guarantee that got pulled. It could have been an employment or wage and labor action that got through the entity and gets to you. But let me tell you, in this case, do you think that Vicky's going to get sued? What do you think? Oh yeah, the little girl did not die. The little girl's a quadriplegic the rest of her life. Horrible. Horrible. Now divorce ourselves for a second that we all want to do everything that we possibly could. So what I'm going to tell you is a little bit about what happened to all of those assets under various different laws. So let's see what it is. Maybe it could have been different. So let's just start with the house. So the house is very, very much governed by state law. All right. So it depends on where you live. If you live in Texas, you keep your house. 100%. Doesn't matter if it's a $2 million house, $500,000, $1 million house. If you live in Florida, where OJ used to live, okay, before he got moved to Nevada, all right? True, he lived there, an unlimited homestead exemption. So then, even this morning when I was speaking to a group of executives here in California, I said, okay, and what do you think under California law, and I'll give you the other states, it's all in the material that I'll send to you, do you think you'd keep your house or lose your house? Half of them said, oh, we think we lose it. Half of them said, oh, no, we keep it. There's like a homestead in California, right? So the answer was, nobody knew. And when a client, you're sitting with a client, there's a home, and they have equity in their home, I think you should know. You should. You're their counselor. That equity, which maybe they didn't have that much equity and put it someplace else protected, they'd be better off, may not be so safe. So here's the deal in California. California says, if you're a single person living in the house, it's $75,000 of equity is exempt. If there are 2 people living in the house, it's $100,000. And if we have someone over age 65 or a disabled person, it's $175,000. If you have more equity than that, house is sold, and you get a check for $100,000. And people ask me, they say, that doesn't really happen, does it? Yes, it does. Every day of the week. Believe me, go to the courthouse and watch it for yourself. It happens all the time. Now, here's a question for you. So, in different states, Nevada is 500,000, Oregon is 60,000, Colorado is 60,000, but it's 90,000 in Colorado. Literally, they write this in the code if you're elderly. And so I said, okay, well, let me look up elderly. If you're 60 years old, you're elderly in Colorado. So every state, Pennsylvania has no exemption from the claims of creditors on a house. So it goes Kansas, 100%. So it depends where you are, where you live at the time. So let me ask you a question. When Vicky hit that child terribly, and they live in California, why does Paul lose his interest in the house? The husband. Anybody know? Because California is a community property state. So I say to all of my advisors, well, what does that mean? Well, it's 50-50. I said, no, it's not. What it is it's 50-50 is divided that way if you get divorced, true. But during the course of the marriage, it's one big pot. And Vicky's liability becomes Paul's. Paul's becomes Vicky's. It becomes a community. They look at community property as an asset, but what did they fail to remember? We have community liabilities as well. We look at the whole pot, and it goes away. So two people done that. Now, so I said to my wife, who's sitting in the back over there, you know, I said, I feel really uncomfortable if I'm working away all my life, and you go out and run somebody over, and we lose everything we worked our life for. So it's California, you know, there's 11 states that say yours is yours. It's all mangled up. So I said, well, maybe there's got to be a way out. And there is. So one way out is that my wife and I could have entered into an agreement that said, you know, and you can't do it when, you have to do that, you know, we don't want to be in the community properties. We want to be out. And we want to own all of our assets 50-50 together, married as sole and separate property. And your liabilities are yours and my liabilities are mine. And it's great. That's the way it would be if we lived in Oregon, New York, Massachusetts, Florida, you know, Ohio, Tennessee, you know, all those 39 other common law states. And then, if my wife crashes the car, God forbid, and kills two people, only she is subject to the claims of that creditor, and only her assets. But it changed something else. So it took half off the table, right? Pretty good. I like that. But it did something else. It changed the legal remedy. Can they toss me out of my house because of my wife's action? No. All they'll be able to do is what? Place a lien over her 50% interest in the home while we attempt to negotiate the problem and get it resolved. So I'd rather do it from sitting inside my house than outside my house. The other way, without it, the house is gone. You know, we're just burping and chirping on the curb saying, how could this happen? It's America. I hear it all the time. People say, how can this happen? It's America. It's our home. I said, you know, remember the Greeks? Don't kill the messenger. I didn't make the rules. Those are the rules. So we need to take a look and see what laws we're under, how to protect homes. And boy, I tell you, when you tell your clients about these issues and tell them that there's some methodologies that they can use to protect their residents and how important it is to them, because it's more than just a house, for many it's a home. You get elevated as an advisor. So now, let's go and click over, hey, what about that $500,000-$600,000 they had with you guys and gals? Think they keep it or you think they lose it? Psh, gone. Oh, there goes all your advisory fees and stuff on that too. And terrible for them, they lost their money. That was unprotected. What about the rental property that they had? Because they kept it in their, no, not protected, they kept it in their trust. And the living revocable trust provides zero asset protection. So they lost their rental property. This is not good. Now let me ask you another question. What if they would have had a liability at the rental property? I see this one all the time. You know, someone trips and falls on the stoop of their rental property, cracks their head, they get sued. It's their entire net worth. They said it didn't have to be a car crash, it could have come from the rental property that they own, but they have insurance. They're right, okay? So that's gone too. What about the 529 plan? Anybody know the deal on the 529 plan? Most of you don't, but you will know now. Oh, you do, because you work with me. Don't get funny. Anyway, funny guy. So here's the deal. 529 plans are really, really interesting. We know we lost the money, right? We lost the house potentially. We lost the rental property. Now we have this money in the 529 plan. So here's the deal. Under federal law, because I don't have time to go through all the state laws today, we'll just do federal law. Here's the deal. Money that sits in a 529 plan for less than a year is subject to the claims of creditors. Fair enough? Money that sits in a 529 plan from months 12 to 24, so Paul's got 4 kids who are beneficiaries, it's $5,000 per beneficiary is exempt from the claims of creditors. So that's 20 grand. Money that's in a 529 plan over 24 months is exempt from the claims of creditors. Can you take it back out? Oh, tell me you can't. can take money out of my grandkids' 529 plans. Right, I have. But anyway, just joking. But you can. Can I take it out and use it for myself to take flying lessons at the University of Colorado? Can I do scuba diving lessons at the University of Hawaii? Yeah. Can I take it out, pay tax on the earnings and a 10% penalty? Sure, yeah. But yet, that money is still protected from the claims of creditors. Not bad. Just don't set them up and load them up 5 years in advance. When? After the wreck. Can't do it, but beforehand you can. So now we cruise along a little bit. So now we know the 529 may be safe, but now we have all that life insurance cash values, right? Now the presumption is, across the board, for many of you, that the cash values of life insurance are exempt from the claims of creditors. Pretty good presumption, right? Widows, widowers, orphans, children, public policy. Oh my God, it's life insurance. Who could be so cruel and mean as to deal with that? And 39 states say that life insurance cash values, not put in fraudulently after the fact, that are made to a named beneficiary are exempt from the claims of creditors. But I'll tell you one state that's not one of them. California. So California says, well, here's the deal. California has a dual special for all of you, and I'll give you a solution to it. California says that $9,300 per person of life insurance cash value is exempt from the claims of creditors. Everything above $9,300, gone. What the hell? So now California goes a little further, and this you need to understand. How about the death proceeds of a life insurance policy? Is that exempt from the claims of creditors? So I die, I have $5 million life insurance policy that I left to my wife. She'd love it, she'd love it, we're cats. Anyway, so she did $5 million, all right? Now in almost every single state, as a matter of public policy, that $5 million of life insurance proceeds that goes to my spouse is exempt from the claims of creditors. So here's the scenario. I'm on the freeway, my fault, I cause an accident, 2 people are killed, I'm killed. The $5 million worth of life insurance pays off. In California, they can use those life insurance proceeds in a judicial setting to turn around and see how much my wife needs. And they will only allow the free amount to go to my wife based upon what she needs, and the needs are based upon a subsistence amount and not upon her lifestyle. Only state in the union that does that. It's not a freebie. So what does that tell you? All of you talk about life insurance with clients, a majority of you. And most of you say this: you don't need to put your life insurance in a life insurance trust, right? Because your estate is what? Not big enough, right? You don't have $11.5 million, you got $5 million worth of assets, it just sold you a $3 million policy, $9 million. No, federal government's not going to take 40%, right? So you don't do it. But there's another component now, isn't it? If those life insurance policies are in a life insurance trust, then the cash values will be exempt from the claims of creditors. We can build in spousal lifetime access provisions, and the death proceeds will always be protected for your family. So there's two sides, and you have to say to yourself, when the greedy, overzealous attorney comes to play, and you sold the life insurance, and God forbid that situation came up, and you didn't make your client aware of the fact that those life insurance proceeds are subject to the claims of creditors where they could have not been had we given them proper advice. Because when we're signing as an agent, you're signing as an agent, we may have a problem. Hasn't happened yet, but I can see it coming because we're lawsuit crazy in this country. So we move on a little bit. So the life insurance and a life insurance trust kind of protects that. So what about the 401k? Think it's safe? What do you think? Yes. Why is it safe? ERISA trust. Okay. So how about a simple definition of an ERISA trust? It means there's at least one statutory employee. True? What if I have a solo K, 401k, and it's just the doctor? And the doctor and his wife who's the nurse. Just like they come out in the movies, you know. I had 2 doctors like that just the other day. So, now what? Subject to creditors. Perhaps. Okay? It's no longer an ERISA qualified plan. So, here's the deal. Assuming it's an ERISA qualified plan, you know, it meets the specifications, then that 401k is exempt from the claims and credits. We all agree with that? Sounds good, you tell your clients that, it's great. Now, let's just move that a little further. If it's not an ERISA plan, because we want to have another beneficiary, it's subject to state law. And in 39 states, they treat a qualified plan the same as an ERISA qualified plan. Fair enough? All right, so now let's go back to the 401k, and then we'll add in the Jewish accounts, IRA and Roth. But when we turn around and go back to the 401k, if the 401k is safe, what if we want to take money out of the 401k? Ooh, part two. Part one, you can't take away my $500,000. If you take it out, I'm going to take it away from you. Now what do? And we're coming up to age 70 and a half, distribution. What now? Oh my God, this is terrible. What are we going to do? What do you think? It depends upon, not federal law anymore, the money out depends upon state law. States have 3 different rules, and you should know what they are for your state. You ask me, I'll tell you what they are. 1, the state can take it, when you take it out of the retirement plan, it's your money, I have a judgment, it's now my money. State says, no, what is it really? It's deferred what? It's deferred compensation. Money that you put aside, now you're going to take it and pay tax on it, subject to the state's wage garnishment rules. California, 25%, Texas and Florida is not allowed. All right? So 25% of it would go to the creditor, 75%. And then there are a few exceptional states that say, if the tree is exempt, the fruit of the tree is exempt. California, believe it or not, is the third. So if you have $2 million in a qualified plan in California, a risk qualified plan, and it's exempt, and you take out $1 million and buy a boat, the boat remains an exempt asset because it came from an exempt source. A lot of people don't know that. So now we have that. But now what about IRA rollover and IRA? So is that an ERISA qualified plan? No, there's no employee. Oh crap. Now what? Qualified plan, 39 states, exempt from the claims and credits, subject to how we take it out. Agreed. But now, what happens there if we take the money? What happens to that? It's not an ERISA qualified plan. So in California and in the states that don't recognize the ERISA qualification, we have finally, 5 years ago, said that if we can trace the money that's inside IRA's rollover back to an ERISA qualified plan, it'll keep its exemption. And the flags go up, we're happy, all's well and good. What happened to the other IRA, the traditional IRA, who put 2,000, 5,000? Now in California that says that is subjected to a judicial determination based upon the reasonable and necessary test. If all the other stuff is safe, what do you think the court's going to say? Give it to the creditor. So let's say you have $150,000 in the IRA. You with me? And the court says, take the $150,000 and give it to the creditor, which you have to. Who pays the tax and the penalty? You do. Ooh. Right? That's bad. So maybe, just maybe, we should consider looking at the 401ks that we have and rolling that back. All right? And maybe we need to do some things to protect that pile of money, because not only is it subject to a tremendous amount of tax, estate tax, income tax, state tax, it's also subject to tremendous asset protection nightmares. Okay, what about the box of gold for $60,000, Daryl? What about that? $8,000 worth of gold under the bed. What do you think? What?
What gold?
I know I put the gold in, don't you? I put the gold in for a very specific reason. See how the hell I'm doing? I guess I'm doing fine. You're lying and perjuring yourself now. All right? Oh crap. They don't know about it. They don't know about it. So here's the deal. Remember I said we're the most sophisticated system in the world? God forbid we get a judgment against you. The next step in the process is called the judgment debtors examination. All right, Lanny, in you come. You go before Judge Schmo, right? Raise your right hand, just like Sessions did and Comey did. And you lie, you go into jail. All right? Now, Lanny, do you have any gold, precious metals in a box under the bed? Have you given any to Uncle Louie? Have you put it in your kid's dresser? You know, if you lie, Lanny, you're going to go to jail. We've got bigger fish to fry. We've got a $25 million judgment here. You're worried about $60,000 worth of gold. Oh, Harry, how do you know about the $60,000? Lawyers don't ask questions they don't know the answers to, all right? So you see what happened, you needed to get a home equity line of credit. a couple years ago, came up, you know, with time to renew. And, you know, in the old days, what would happen? You walk into the bank and they say, hey, you know, Mr. Lana, you want a line of credit? Here, sign here, we'll give it to you. Then came along Frank and Dodd and Frank and all the rest, which you all know, right? Now you want to get a line of credit, what happens? They want to know everything, including the size of your underwear. It takes 3 months. And on that, they discovered, on your sheet, you put down precious metals, gold, $60,000. And you put it down, right? So I know about that. I also have the charge receipt when you bought the $60,000. So don't lie. We're a very sophisticated system. Don't lie. It's not worth it. The gold is gone. Okay, now could the gold have been protected? Yes, it was in the safe deposit box that was held by an LLC in a different state. Would have been protected. No. We get right to the heart of the things along the way. Oh my God, I got 5 minutes. Shit. I told you it's 3 hours. Anyway, so let's deal with this one. This is a very important one I want you all to know. Critical one. Last 5 minutes, maybe I'll steal an extra 5. So it kind of looks like this. What about the S corporation, the corporation, the Delaware corporation, the LLC, the 3 businesses that we own? Do I keep my businesses or lose my business? Do I lose my company? Do I lose my income? Do I lose my salary? What the hell? It's a separate entity, separate tax, the numbers file, separate tax returns. What do you think? How many people say they think we keep the businesses? Nobody? Oh, wow. Just in Nevada. I use Nevada. The Nevada LLC, the other ones we don't keep. And it's true. We lose all our businesses. And do you know why? No, not at all. Let me ask you a question. Did this liability rise up as a result of the operations of our business? No. Did this liability rise to the owners of the business? Yeah. What do the owners own? Stock. Do I care if it's IBM stock or Mick Hitchcock stock? No. I get the stock because the relationship between shareholders is considered non-intimate. I get the stock. Once I get the stock, I get control. Once I get control, I liquidate the business, take the receivables, sell it to a competitor. It's done. I sell it off to do that. I will tell you that 95% or 90% of your clients that have corporations have no clue to this. They think it's safe because it's in a corporation. They're thinking what? This way? And you're looking that way. More businesses are lost to the liabilities of an owner than they are from the liabilities of the business itself. We're all very well aware of risk management, loss control in the business, but we don't think so much about the fact that if the owner gets it, it's gone. So that's a real issue. Now, you said the Nevada LLC gets it because it's Nevada. Good answer, but no cigar. The reason now the LLC is not lost. We keep the LLC. We keep our job, we keep our business, we keep getting our compensation. Oh, why is that? Now, first of all, understand in one position, we've lost our business and lost our salary. In the other position, we've kept our business and kept our salary. Oh, well, our salary may be subject to a wage garnishment. We've kept our salary, kept our business. You tell me which position you'd rather be in, all right? I think you'd rather be in your clients be in that LLC position. And then people say, just so you know, and I'll tell you the reason for this and then I'll wrap it up. They will say that, well, I spoke to my accountant and they said if I took my corporation and turned it into an LLC, that's the same as if I sold my entire company and started a new one. I got to pay a whole bunch of taxes. That was a dumb idea. I can't do that. Well, they would have been a little smarter. They would have recognized that we could do something which is called a Plan F reorganization, which allows us to reorganize the business into an LLC, but for tax purposes, keep it as an S corporation or C corporation. So there's absolutely no adverse tax consequences, but legally they could never lose managerial control of their business again. Let me tell you, when you sit with a client of yours that owns a business, that owns stock, which is a good percentage of many of them, and you tell them that where you are right now, what you've learned, that they could potentially lose control of their business as a result of a liability, but we have some methodologies and some resources that can make sure that you never ever lose control of your business. If you don't think your stock rose in value at that point, if you don't think they're curious at that point, you've missed the boat of everything that I'm talking about today. I don't want to do that. Now here's the reason for this, just so you know. Making it really simple. Okay, back in the day, remember the day? Back in the day. In the day, America was an agrarian society, right? We tilled the earth, and they put on these covered wagons, and the guys with the stogies went, and they went to the west, and they went to the west, and everybody out here was, it was Lanny's dry goods store, right? Lanny proprietor. There were no LLCs, LPs, inks, things that you need a vaccination for. There were none of those things, okay? All we had was proprietor and partnership. Shake hands, Darryl and I shake hands. We have a general partner, unlimited liability. Then along came, after that for a while, America woke up and said, maybe we want to be a capitalist nation. We want to have big public corporations. We want to get the public to invest. But what are we going to do if Harry invests in Ford and if Pinto blows up? How will Harry invest in Ford if he could lose his house? So let's invent this thing called a corporation. So we could buy shares, and the worst that can happen, he can lose his shares. But Kate, it just meant that there is no relationship. If you're a shareholder of Ford and I'm a shareholder of Ford, so what? There's no relationship. The relationship is considered non-intimate. It's the same as if there's two of us. So if Lanny and Micah are in business together in a corporation, a small S corporation, what do you think they refer to themselves as? Tell me. Partners, right? My partner Lanny, my partner Micah. No, they're fellow shareholders. They are not partners. And they're governed by corporate law. And even though it's the two of them, it's considered non-intimate. So therefore, I can take Micah's stock and I become the new shareholder of the company and trash the company. Unless you pay me off and pay me off big. Every single limited liability company rose up out of partnership law. That's the difference. People even make mistakes and call them limited liability corporations, and they're not. And it rose up under partnership law, and under partnership law, the relationship is considered intimate. So Kate and I go into business together. You're really great operationally. I go out and do sales, all right? And now my wife, sitting in the back, she went to pick up another cat, and when she did, special. Anyway, when she picked up another cat, she wanted to have a big accident and hurt a bunch of people. Now, if that creditor, that community property, would come in and get me and then go in and affect our partnership, what would happen? They could take our equipment. Who gets hurt? Kate. All right? And if they substitute me out and bring somebody else in, that's not fair to Kate. That's not what we signed up for. We're partners. We have an intimate relationship. We work together. So the law for 100 years has said, what we will do is place a lien over Harry's interest in this LLC. And the distributions that come out, not the compensation, the distributions will go to the creditor, but we will not interfere with that business. We're not going to do it. And hence, every single limited liability company is built on that premise. Oh, they're a little better from different, whether it be Nevada, Delaware, Wyoming, California, but they all have that basic premise. So for those of us that have small businesses, the reason that it's become so popular, even though the taxation doesn't change, because we can tax it as an S corporation, C corporation, or a partnership, and in some cases disregarded entities, it works. The one thing you have to worry about, as I begin to close up, is this. And I have tons and tons to talk to you all about, that's why you have material and you can all call me, is that single member LLCs, which are bird of state statute, one member LLCs, we all know them, all right? Do not have the asset protection characteristics that a multi-member LLC does. Because when LLCs were first born, Don, you had to have two people. How can you have a partnership of one? A little difficult. And so the courts have not been very, very favorable to single-member LLCs and have allowed creditors to come in and reach the assets. Multi-member could be 99 and 1, because the court case said if anyone had a peppercorn of an interest. So, I've taken you on a quick tour around the spectrum of various different assets, all different by different states, and to give you some idea, but here's the most important takeaway for every one of you. You're in the financial business, all right? I'm in the financial business too. And let me explain to you, if you bring and talk to your clients, don't practice law, but you talk to your clients about, let us build your assets, let's make sure they're done properly in the event of your death or incapacity, let's make sure that they're protected from the claims of third-party creditors. They can reject that, but they won't. And they will make you a better advisor than you've ever been before.